just kind of running through the jury to see who was in what group. Our first 5 jurors were in group 1 through Ms. Cave, and then the last 3 were ones that were in group 2. That's related here according to the clerk's records. So, who do you want me to talk to, Mr. Prince?
I would request, Your Honor, that you do individual what are on each of the jurors. Even the ones that weren't down there in the afternoon may have spoken to another juror who was. I just think there should be a clear record of whether any of them heard that and what, if any, impact it may have had on the deliberative process.
What's the state's position?
Your Honor, the state's position is a non-issue. It's a general statement that was there. I don't think that it is beyond anybody to think that if parties actually negotiate for cases and plea negotiations in some way, shape, or form. It was a statement made as a whole, as to 6 different cases. As it regards to, obviously it was not directed at this particular case. I think an overall aspect is when somebody hears plea deal, they generally think that it's a slap on the wrist type situation. Most people don't realize that plea deal can be for the kind of things that we obviously see in court, but the general public's impression of a plea deal is that the this case is weak and therefore they're pleading out a case, is typically the way you hear it. Again, it doesn't seem like there's an issue here in any way, shape, or form as it relates to the specifics of the case, and I don't think it was an appropriate thing. I think as a practice it probably shouldn't be done anymore for that manner, but I don't see how it's prejudicial and how that would affect further. We specifically went through individual voir dire with each one of these persons after this occurred. So they would have come in and we would have talked to them about what they knew about the case, what they've heard about the case, and all the other individual voir dire that we did, any press coverage, all the other stuff that we did outside, plus the full voir dire process that we did in the courtroom after these statements had occurred. Might be a different story if they heard it mid-trial, but this is before jury selection happens. This has already been vetted for the most part. So.
I don't think it hurts to ask them whether they have recollection of such a statement by the clerk, and if they did, whether that had any impact on them. Frankly, I would think that most jurors would assume that plea negotiations go on as to all cases, so I'm not sure that it has great significance anyway, but I don't think it hurts to have a record of whether that was said or not. So let's just bring them one at a time. Just put them in the first seat there, and we'll just inquire of them real quickly. Right, Ms. Radulski. You're not in trouble. It's just something we need to clarify. I know this is a little intimidating, but some issue has come up that maybe the clerk of court in her opening comments to y'all when you were first gathered up here on Monday, long time ago, when you first came here, may have said something about plea negotiations going on. Do you remember anything like that being said? Nobody's said anything to you about plea negotiations in this case? All right. All right. Don't talk to the other jurors till we have a chance to talk to everybody. Okay? All right. Thank you. Give done anything wrong, don't be nervous, we're just trying to make a record of it. But there's been a suggestion that during your initial time when you were all brought here as a group downstairs with the clerk of court, that maybe she said something about plea negotiations going on in this case. Do you remember anything like that? What's that? Okay. So nobody said anything to you about plea negotiations in this case?
No, sir.
And nobody's, even other jurors said anything like that to you?
No, sir.
All right, thank you, ma'am. You haven't done anything wrong, so we're just trying to clarify a record issue. There's been a suggestion that in your initial gathering with the clerk of court, Ms. Marshall, that maybe she said something about plea negotiations going on in the case. Do you have any recollection of anything like that being said?
No.
And nobody said anything like that to you?
No, sir.
All right, thanks, sir. Just have a seat there. No reason for alarm. You didn't do anything wrong. We're just trying to clarify an issue that's been raised. A suggestion has been made that during your initial gathering downstairs, that the clerk of court, Ms. Marshall, when she was talking to you, may have said something about plea negotiations going on in the case. Do you remember anything like that being said? No? All right, and nobody said anything to you about plea negotiations, either her or some other juror?
No.
Okay, thank you, ma'am. And you're not in trouble or anything, we're just trying to clarify an issue. There's been a suggestion that when y'all first came in downstairs, you were gathered up as a big group. When the clerk talked to you, that she said that she may have said something about plea negotiations going on in the case. Do you remember anything like that being said? Anybody, any other juror said something to you like that? No. All right, thank you, ma'am. Now, those would be ones who are in the first group. Good morning. You're not in any trouble. We're just trying to clarify an issue that's been raised. There's been a suggestion that in the gathering when y'all were first brought in downstairs in the big group downstairs, that when the clerk talked to you, Ms. Marshall, she said something about plea negotiations were ongoing or something of that nature. Do you remember hearing anything like that?
No, sir.
And nobody said anything to you like that, another juror or anything like that?
No, sir.
All right, thanks, sir. And thank you for being back here, Mr. Beasley, this morning. There's been a suggestion that when y'all were first gathered downstairs and the clerk was talking to you, when you first came in several weeks ago at the beginning of this, that the clerk said something about plea negotiations going on in this case. Do you remember anything like that being said?
Not specifically, no.
Okay. But do you have some recollection of plea negotiations?
There's been so much legal talk in the past 3 weeks, I wouldn't doubt somebody said please something or another, but no, I can't.
You don't have any recollection of that?
No.
It's not, if nobody, other juror or anything like that's discussed plea negotiations with that. If that's come up, is that something that concerns you about the case, that plea negotiations going on or not?
Hadn't crossed my mind.
Okay, thanks, sir. And we do appreciate you being back here this morning. Good morning. And thank you for being back here today. And you're not in any trouble. We're just trying to clarify an issue. There's been a suggestion that when y'all were gathered up downstairs when you first came in that Monday afternoon, when you were first, that's been a long time ago now, that the clerk said something about plea negotiations going on in the case. Do you remember anything like that being said? You remember anybody talking to you anything about plea negotiations in this case? Can't think, don't have any recollection of that. All right, thank you, ma'am. So, further, Mr. Brent?
No, Your Honor.
Anything from the state?
There you go.
All right. So you need a few minutes to, how long do you want?
Yes, sir.
15 minutes?
Yes, sir, that'd be fine.
All right. And then we'll start with the presentation. All right, tell the jury we're going to be about 15 minutes. We'll be in recess. Or do we stand, Brent?
Your Honor, after further discussion, Mr. Segura has indicated he does not wish for us to put on any witnesses or argument. He's also instructed us that he doesn't want to do a Spencer hearing, request a Spencer hearing at all. So I think we need to proceed with the colloquy if that's his decision.
Okay, but, okay. Stand up again, please, Mr. Segura. What Mr. Prince indicated, is that correct?
Yes.
All right. Now, the second part of what he talked about, I want to make sure you understand that's not waivable. The court is required, let me start over again on that. Whatever the jury does, if they recommend the death penalty, which of course is much more likely if you don't present anything and you don't make any argument, I still have to make an independent determination whether the death penalty is appropriate or not. And Mr. Prince called that a Spencer hearing. I would require the attorneys to present to me whatever evidence they have gathered. That it's your decision here today, but at the Spencer hearing, that will not be your decision. I will require them to present the evidence to me. So if what you're trying to do is avoid it being presented in court, it's going to be presented at some point in time, because I have to make a decision also, not just the jury. Do you understand that?
Yes.
Does that change your mind about what you want to do here today?
No.
So you instructed your attorneys not to present any evidence, is that correct?
Yes.
And you've instructed your attorneys not to make any argument contrary to the death penalty, is that correct?
And or call any witnesses.
Right, and that's what you want to occur here today?
Yes.
And do you have any questions about what you're doing?
No.
Anybody pressured you into doing this?
No.
Anybody kind of made any kind of threats against you to try to make you do this?
No.
This is your own personal decision.
Yes.
State, wish to make any further inquiry?
No, Your Honor.
All right, thank you, Mr. Segura. All right, so with that, I will find that his waiver of mitigation is freely and voluntarily made. We will proceed with the jury. What do you anticipate saying to the jury in terms of a opening statement or a closing argument? What's going to be said?
That we will not present an opening statement or a closing argument, Your Honor.
You're just not going to say anything at all?
Correct.
Okay. Okay. State, have any issues we need to raise before we start with the jury?
Your Honor, I guess procedurally, how we need to address it we need to introduce these exhibits, and I don't know if we're going to do an opening, do we need to close it, or just do one argument that is?
Well, that'll be up to you. I'll offer you an opening. You can make it or not. I'm going to offer it to the defense. Apparently, they're going to decline. Then you present any evidence you wish to present. They're going to be offered the opportunity to present evidence. Apparently, they're going to decline. Then you're going to be offered an opportunity to make a closing argument. You can make it or not as you see fit. They're going to be offered opportunity. Apparently, they're going to decline. And then I will instruct the jury. That's how it will proceed. Now, of course, before we move to that, we need to have a little more discussion about jury instructions on the final part of it. But that's how things would proceed. Do you have an issue with any of that?
No, sir.
Defense have an issue with any of that?
No, Your Honor.
We're ready for a jury?
Yes,
Ready
Your
for
Honor.
the jury?
Yes, Your Honor.
Okay. All right. Let's have a jury, please. everybody be seated. Thank y'all for being back here today. We appreciate you kindly returning. I'm sorry we were delayed. We've been working. Don't want you to think we've been goofing off. We've had a couple of issues to deal with. I think you'll see that this thing's going to move pretty quickly from here on out. I'm now going to give you some preliminary instructions as to the penalty phase. Members of the jury, you have found the defendant guilty of 4 counts of murder in the first degree. The punishment for this crime is either life imprisonment without the possibility of parole or death. The attorneys will now have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you're not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant will be given an opportunity to present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence, along with the evidence that you heard during the guilt phase of this trial, is presented in order for you to determine, as you will be instructed, whether each aggravating factor is proven beyond a reasonable doubt, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty, whether mitigating circumstances are proven by the greater weight of the evidence, whether the aggravating factors outweigh the mitigating circumstances, and whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence and after argument at counsel, you will be instructed on the law that will guide your deliberations. An aggravating factor is a standard to guide the jury in making the choice between life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of a crime or the harm to a victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond every reasonable doubt, and you must not consider it in providing your verdict on the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. Before moving on to mitigating circumstances, you must determine that the aggravating factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factors are sufficient to impose death, do not move on to consider the mitigating circumstances. Should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, it will then be your duty to determine whether the aggravating factors that you unanimously find have been proven beyond a reasonable doubt outweigh the mitigating circumstances that you find have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proved beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as the sentence to be imposed. Next thing that will be offered is an opportunity for the attorney to make an opening statement.
Ladies and gentlemen, it is my responsibility to present the state's case for the penalty phase. The state of Florida is going to ask you at the conclusion of this phase that you impose the death penalty for the murders of Brandi Peters, Tamiyah Peters, Taniyah Peters, JaVante Segura. The evidence of the guilt phase that we went through can be considered by you as evidence in the penalty phase. And the state will primarily rely on it to prove the aggravating circumstances that are alleged to be present in this case that warrant the imposition of the death penalty for each of the murders in this case. The only additional evidence that will be introduced are complete copies of the medical examiner's reports on each of the victims. The aggravating circumstances the evidence will prove are: 1, the defendant was previously convicted of another capital felony in this case. And what that basically means in the context of this case is a contemporaneous conviction. That means as an aggravating circumstances for Brandi Peters, you can consider the fact that at the time she was killed, that also Tamiyah Peters was killed, that Taniyah Peters was killed, and that JaVante Segura was killed by the defendant. And that would apply for the same for Tamiyah Peters. As an aggravating circumstances in her case, you can consider that the deaths of her mother, her sister, and her brother also occurred at that time. The same for Tamiyah Peters, and the same for JaVante Segura. The second aggravating factor in this case is that this capital felony, this murder, was committed for the purpose of avoiding lawful arrest or effecting escape. And what that means, and the court will instruct you, is that includes the elimination of a witness. That means that, in this case, the defendant's child support didn't involve the twins. The only reason to eliminate them was because there were potential witnesses in the case. Same could apply for JaVante Segura, that while he may have been the subject of the child support, it was it was Brandi Peters who was in fact the one seeking it, and that the money would have been paid for it all belonged to the state. With her out of the picture, with Mr. Segura being the listed father, he would have had custody of the child and there would not be any child support. So there was no reason to kill that young man either, except to eliminate him as a witness in this case. That leads me to the third aggravating circumstances, that this crime was committed for financial gain, for some financial benefit for the defendant. The fourth, and a very weighty circumstance, would be that the crime was committed in a heinous, atrocious, or cruel way. you looked at the brutality of the murders. We will be relying on the evidence that you heard from the crime scene, people who spoke, the medical examiner, and the photographs. So you've heard and seen that evidence. There will be a little bit more discussion after the judge instructs you on what the elements of what heinous or cruel are, how that ties into the evidence in this case. And we'll do that at closing. The fifth will be that this crime was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Again, the judge will give you more instructions on what those terms mean, and at closing argument, we will have a discussion as to how the evidence plays into the evidence in this case plays into that instruction and what that means and how it applies to each of the deaths in this case. That capital felony was committed on a person less than 12 years of age. Tamiyah, Taniyah, and JaVante were all less than 12 years of age. They were 6 years old, and 3-year-old, respectively. And that will be the final aggravating circumstance that we will be asking you to consider. At the conclusion of this penalty phase, the state will be asking you to determine that the death sentence is the appropriate sentence for the crimes Mr. Segura committed against Brandi Peters, Tamiyah Peters, Taniyah Peters, and JaVante Segura. Thank you.
Your Honor, the defense declines to make a statement.
All right, at this point, we'll allow the state and the defense the opportunity to present evidence. We'll start with the state.
Your Honor, prior to, as pursuant to the stipulation, the state would introduce State's Exhibit 159, which is the complete autopsy report of Brandi Peters. State's Exhibit 160, which is the complete autopsy report of Tamiyah Peters. 161, which is the medical examiner's complete report of Taniyah Peters. And 162, which is the complete autopsy report of JaVante Segura.
It's my understanding they'll be admitted by stipulation.
Yes, Your Honor.
All right, they are admitted. Further testimony, Mr. Evans?
No, Your Honor.
All right. The defense wish to present evidence.
We do not, Your Honor.
All right, so that's going to be the evidence that you're going to hear. I need to meet with the attorneys briefly, and I say briefly, it may take a little bit of time to discuss the jury instructions. We've got a draft of those prepared, but it's going to take me a few minutes to get those done and to make copies of that. So, go back in, have a cup of coffee, relax. We'll be with you as quickly as we can. Is there some reason we have that one?
Publish them to the jury, Your Honor, so
All right, everybody be seated. Mr. Segura, your attorney has now announced that you do not desire to present evidence. You still have the opportunity to change your mind at this point in time. If you wish to present anything, do you wish to present anything at this time, Mr. Segura?
No, Your Honor.
All right. All right, let's talk about jury instructions. I found a typo in the aggravating factor number 2. Just was an extra Y in there. What else have we found as to the jury instructions? Say.
Your Honor, I did have a question about the draft. We had the special instruction to number 2, purpose of avoiding arrest. I don't know if we received a final copy which included the additional language that the state had requested and the court had granted. That the
No, I need to add that in. about the primary motive.
Yes, sir.
Right. Frankly, I forgot that. Thank you for that. I will have that added in. What else?
Other than that,
Okay. As to the instructions, the defense have any issue with the instructions?
No, Your Honor, it's acceptable.
All right. The verdict form gets very complicated. We need to discuss that. As to aggravating factors, as to Ms. Peters, I don't see where the state has a basis to do the void or prevent lawful arrest as to Ms. Peters. I understand the theory is the children were killed to avoid that, but avoid them being able to testify against her being killed, but I don't see any theory by which she's killed to avoid lawful arrest, but I'll let you be heard on that if you desire.
no, sir, except will be removed.
I'm sorry.
We don't have any objection to it being removed.
All right, so I'm going to strike that. As to the children, I have a question whether the financial gain aggravator is applicable. I understand your argument as to Ms. Peters, but I don't see how that establishes committed for financial gain as to the children, but I'll let you be heard on that if you desire.
To the twins, we would agree to it being removed.
Okay. What's your argument as to JaVante?
Well, the fact that child support, at least continuing child support, would cease upon his death. What we argued to the jury that, if he took custody of
He what?
if Mr. Segura took custody of JaVante Segura, then he would in fact be owing any child support to himself. So there wouldn't be, he wouldn't have to deal with Brandi Peters and have to pay outside child support.
Defense?
Your Honor, from my understanding, the judgment would have caused Mr. Segura to owe the state of Florida, not JaVante Peters.
I'm going to strike it as all three children. I think it's a stretch to say. I mean, I think it is a fact. One of the witnesses did say it would cease upon his death, but I think it's a stretch to say that's what motivation was. So I'll strike those matters. Anybody found anything else in the verdict form? And they're quite complicated, so I hope everybody's read them. And if I've got something out of place or mixed up, let's deal with it now.
Nothing that I observed, Your Honor.
Defense?
Nothing, Your Honor. It's acceptable.
What's that?
It's acceptable.
Okay. All right. All right. Anything else from either side?
No, Your Honor.
All right. We'll go get those finalized and we'll be prepared to move forward.
Yeah.
seated, please. I realized after I sent instructions into you, had not taken out the victim impact paragraph. I've now taken that out. Other than that, it's what I sent in previously. Any issue as to the jury instructions from the state? It's the same as what I sent in before, Mr. Evans. Other than I took out the victim impact statement.
Yes, sir. They're fine.
What's that?
It's fine.
All right, defense?
No, Your Honor.
All right, so we're ready for jury. What I'm going to do is I'm going to instruct them down to the part where it says in just a few moments, so the last page, I'll stop there. Then we'll give you an opportunity to make any closing you desire to make. All right? Have a jury, please.
Jury's in the courtroom.
All right, everybody be seated, please. All right, next thing I'm going to do is instruct on the law that applies to this part of the case. Members of the jury, you've heard all the evidence and argument of counsel. It's now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible punishments: life imprisonment without the possibility of parole, or death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proved beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are: 1, Henry Segura was previously convicted of another capital felony. A contemporaneous conviction for a capital felony may qualify as a prior conviction under this aggravating factor. The crime of first-degree murder is a capital felony. 2, the first-degree murder was committed for the purpose of avoiding or preventing a lawful arrest. The aggravating circumstance applies where the dominant motive for the murder was to kill a witness. The existence of other motives for the killing does not preclude the application of this aggravating circumstance. 3, the first-degree murder was committed for financial gain. 4, the first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to Brandi Peters, Tamiyah Peters, Taniyah Peters, or JaVante Segura. 5, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. 6, Tamiyah Peters, Taniyah Peters, or JaVante Segura were persons less than 12 years of age. As explained before the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond every reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find that each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility for parole. At such point, your deliberations are complete. Excuse me. If, however, you unanimously find that one of the, or more of the aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. If you do unanimously find that the existence of at least one aggravating factor and that the aggravating factors are sufficient to impose the sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, for life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. It is the defendant's burden to prove that one or more circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: Henry Segura has no significant history of prior criminal activity, the existence of any other factors in Henry Segura's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Your decision regarding the appropriate sentence should be based upon proving aggravated factors and established mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravated factors that you have unanimously found to exist outweigh the mitigating circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or value by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the results of each juror's individual weighing process, even if you find that sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I've said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. Your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous, and your decision to impose the sentence of death must be unanimous. You'll be provided with a form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. Deputy. All right, let's look at the verdict form. Unfortunately, it's a little complicated because we have the steps that you have to go through, and for each of those, you have to consider it as to each count, and there are 4 different counts, so it gets a little complicated, but I think once you get into see the pattern of it, it'll be fairly clear cut. So the first thing you have to look at are the aggravating factors, which is in subsection A. The state has alleged 6 aggravating factors. You need to make a decision as to each count what aggravating factors have been proven as to that particular count. The first one would be as to Brandi Peters in count 1. The court has eliminated 2 of the 6. So you have 4 aggravating factors that you're to decide whether have been proven beyond a reasonable doubt or not. You would check each one that you find has been proven as to count 1, dealing with Brandi Peters. Then you would do the same as to count 2, as to the children in counts 2, 3, and 4. They're the same. The court has eliminated 1 of the aggravating factors as to them. So there are 5 potential aggravating factors that you're to determine. So as to each of the aggravating factors, as to each of the counts, you would decide whether the state has proven them beyond a reasonable doubt or not, and you would check that. If you go to page 5, the bold language at about 2/3 the way down that page is very important, so let's read through that. If you answer yes to at least one of the aggravating factors listed in a count, so it's done by each of the 4 counts, please proceed to section B as to that count. If you answered no to every aggravating factor listed in a count, do not proceed to section B in that count. Henry Segura is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole as to that count. So you have to consider it as to each of the counts. If there are no aggravating factors proven beyond a reasonable doubt as to a particular count, you are done. You don't have to do anything further as to that count. If you find that at least one aggravating factor has been proven as to the count, then you would move on to B, which is sufficiency of the aggravating factors. And again, it's broken out into each of the 4 counts as reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in section A. We, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. So as to each of those that you found an aggravating factor, you need to answer that question, yes or no. Then let's go to page 6. The bold language at the bottom of page 6, I think, is worth reading through. If you answer yes to section B in a count, please proceed to section C in that count. If you answer no to section B in a count, do not proceed to section C in that count. Henry Segura will be sentenced to life in prison without the possibility of parole as to that count. So any of them where you say no, your job is done. If you say yes, then you need to go to C. C relates to mitigating circumstances. Again, it's broken out by counts. It says 1 or more individual jurors find that 1 or more of mitigating circumstances were established by the greater weight of the evidence, and you would check yes or no. Now, note this is not necessarily a unanimous decision. This is the first time where it does not have to be unanimous. It says 1 or more individual jurors, so any juror could determine that this is yes. It says, please, the bold at the bottom of the page, please proceed to section D, regardless of your findings in section C. Then in D, the question is, we, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt back in Section A outweigh the mitigating circumstances established, which are found in Section C. Would be yes or no. Again, it's broken out by counts. You would answer yes or no as to any where you're still proceeding. In other words, there are some where you may have already concluded from the prior subsection. If you answer yes to, now I'm on the top of page 9, look at the bold language. If you answer yes to Section D in a count, please proceed to Section E in that count. If you answer no to Section D in a count, do not proceed. Henry Segura will be sentenced to life in prison without the possibility of parole in that count. Under E, the question again is broken out by count. Having unanimously found that at least one aggravated factor has been established beyond a reasonable doubt back in Section A, that the aggravating factors are sufficient to warrant a sentence of death as to Section B, and the aggravating factors outweigh the mitigating circumstances, Section D, we, the jury, unanimously find that Henry Segura should be sentenced to death, yes or no. You would do that as to any counts that you're continuing to proceed with from early. If, and now at the bottom of page 10, the bold language, if your vote to impose death is less than unanimous in a count, the trial court will impose a sentence of life imprisonment without the possibility of parole in that count. It would then be dated and signed by the foreperson. So I know that's a little complicated, but it's kind of, I think if you follow it along, I think it flows through it. We've tried to make it self-explanatory. Now back on the jury instructions, page 5, right after read verdict form, the fact that a jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. I've previously instructed you on weighing the evidence and rules for deliberation. You should consider the instructions I gave you during the initial stage in making your determination. A copy of those instructions will be provided to you for your consideration. Now, I'll come back to the last page after the attorneys have been given an opportunity to make give a closing argument. Mr. Evans.
Ladies and gentlemen, as the judge has indicated, this is a weighing process. It's to weighing whether or not there are sufficient aggravating circumstances, and they've been listed in this crime to warrant the imposition of the death penalty. The state would submit to you that there are. And when you compare them to the weighing factor of any potential mitigating circumstances, any mitigating circumstances pale in comparison to the crime that was committed on these 4 people. And that there are sufficient aggravators to outweigh the mitigators. And that the appropriate sentence in this case is to impose the death penalty on each and every count in this case. Now, let's talk a little bit about the case. As we have indicated, the aggravating factors, prior conviction, which is the contemporaneous conviction of the 4 murders. That was done for avoiding arrest, and that's the witness elimination, which the court has instructed you on, and you have before you in the instructions. It was for financial gain. It was done in a heinous, atrocious, and cruel manner. That it was cold, calculated, and premeditatedly done, and that 3 of the victims were under the age of 12. As the court indicated to you whenever he was going over the verdict form, there are going to be some aggravators that apply to some of the victims in this case, their murders, but not necessarily to all. For instance, we know right off the bat, number 6, we know that Brandi Peters was not under the age of 12, so that aggravating circumstance would not apply to her. You also know that, for the twins and for JaVante, that the court, the jury or the verdict forms are not going to include an indication of whether or not financial gain being a motive in this case, as one of the dominant motives in this case, apply to them. And we also know that you will see that the purpose of avoiding arrest, the purpose of witness elimination, isn't being requested on Brandi Peters. So I'm going to go over the number of aggravators in line. Just recognize there will be some aggravators that will apply to some victims, some aggravators that will not apply in their murders. So, and I think the verdict form accurately reflects that. So the ones we're seeking in each of the individual murders are set forth in the verdict form. All right, the contemporaneous conviction. It includes, as noted, contemporaneous conviction for a capital felony may qualify as a prior conviction. In this case, I think you will see that the evidence clearly shows that that aggravating circumstances is shown beyond a reasonable doubt in each of the crimes that have been committed. And that is because that in Brandi Peters' murder, that we see that there were other murders that occurred. In Brandi's case, the other contemporaneous convictions are for the 3 kids. And while there will be some photographs that were proposed that will be placed before you, I'll let you know now there will not be a tremendous amount, simply because you have them, you're able to review them. You reviewed them during the guilt phase. They were shown to you a lot. You know what they see, and you can imagine what they are, and go back and see what they are and compare them what they are should you have any additional questions. So I will do my best to limit those. So I believe in each and every case that there will be at least 3 contemporaneous convictions for murder that would apply in each of the 4 victims in this case. Therefore, I submit to you that has been proved beyond a reasonable doubt, and that you should find that aggravator exists. I also believe, whenever you take a look at the evidence, that you will, in your weighing process, that the weight given to that should be a very great weight should be placed on it. And very great weight should be because you have 4 victims in this case. This is not a case of a single murder. It is a multiple murder. It is a murder of a family. It is a murder of children. Now, the purpose of avoiding arrest. It was committed for avoiding or preventing lawful arrest or effecting escape. And as your jury instructions show, the judge has shown you that this applies where the dominant motive of the murder was to kill a witness. The existence of other motives for the killing does not preclude the application of this aggravating circumstance. We have 3 kids. Now, these 2 young ladies had absolutely nothing to do with the child support in this case. The only reason the statement that they were killed is because they could identify the defendant. He had a choice, and we'll touch on this during the cold, calculated, premeditated part of it. If he wanted to eliminate Brandi Peters or eliminate JaVante Segura, he didn't have to kill these 2 little girls. he had a plan. We know he had a plan. Again, we'll touch on it a little bit more. He went in either knowing they were there or not caring they were there, that he was going to kill everybody there. The reason these two little girls were killed was because if they weren't killed, they could have walked in this courtroom, walked up and got on that stand and said, "This is the man that killed my mama. This is the man that killed my little brother." We have JaVante. It wasn't necessary that he kill him. He too could identify the defendant in this case as being the killer of his mama. The defendant's plan included going there and doing that killing and killing these witnesses. Because where were they earlier in the day? They wasn't necessarily at home. He could have planned this when they weren't there. He could have lured Brandi Peters away from the home and did it there. But he elected not to. The murder was committed for financial gain. It takes a second for it to load. We have the fact that the child support payments were owed. They were coming to be owed. And he killed this family because he was trying to avoid that responsibility. We know he attempted to go in, and the dates of when all this occurred, everything started coming together. We'll touch it a little bit more on that cold calculated premeditated. But the dates were significant. Heinous, atrocious, and cruel. It means extremely wicked, shockingly evil. When you view the photographs of what occurred in that home, how it occurred, and why it occurred, these are very appropriate words. Extremely wicked, shockingly evil, atrocious, outrageously wicked and vile. Cruel, high degree of pain with the utter indifference to or even enjoyment of the suffering of others. It's a kind of crime that's included is to be as especially as cruel one as comes by additional acts that show the crime was conscienceless, pitiless, unnecessarily torturous to Brandi Peters, Tamiyah Peters, and Taniyah Peters or JaVante Segura. It also says in the jury instructions that the court read to you that, and I'll go back, designed to set the high degree of pain, utter indifference to, or enjoyment and suffering of others. Again, we go back. He could have committed this crime of killing Brandi Peters without doing this to her children. We also know, as we're going through the degree of injuries. And I'll take these as we go through each of the victims on the heinous, atrocious, and cruel. The number of injuries, remember this came from the autopsy report of Dr. Flanagan and through her testimony and the testimony of the other witnesses in this case as to the amount of injuries and the degree of injuries that occurred to Brandi Peters. Brandi Peters was shot. I believe the testimony was she had 8 wounds and there were at least 7 gunshot wounds. We know from the back of the house, from the bedroom, all the way through the house, even outside in front of the house, her blood was found. She fought back. We see the defensive wounds to the point where her nails were ripped off. We see where she was trying to block the blows that the 7 gunshots didn't kill her. But it took her being pulled back into the house and beat repeatedly on her head and face to kill her. Heinous, atrocious, and cruel. Brandi Peters was very aware of a number of things in this case that showed that this aggravator has been proven. She was very aware of the fact she was attempting to be killed. And at some point, maybe as she got drugged back in the house and started getting beat, she was very aware that she was going to die. She fought as hard as anybody you will ever see in this situation. From one in the house to the other, then pulled back in. Her hands up trying to block the blows that repeatedly fell on her head over and over and over and over and over. And I ask you another question. What kind of rage, what kind of hate, what kind of vile, what kind of wickedness played into the beating that this woman took? The other thing she knew, which probably is even worse, more vile, more wicked, more cruel than anything else, she knew she was going to die. But she knew 3 little babies were going to die with her. And they did. She died knowing that. And he killed her knowing she knew that. This aggravator has been proven. And it, if nothing else alone, warrants the imposition of the death penalty in her case. Heinous, atrocious, and cruel as it relates to the kids. Tamiyah was shot in the back of the head. Tamiyah's death, somebody could say, well, you could say it was somewhat merciful because she didn't have to go through the drowning that her siblings went through. She didn't have to go through the beating that her mother had to go through, shooting and beating. I submit to you, it was not merciful. It was merciless. In its own way, it was just vile, cruel, and wicked as anything else. Remember Henry Segura? He told I believe they said at least 23 to 26 lies they were talking about, they were documenting as they were going through his statement. But one of the biggest lies he told that wasn't brought up then was his claim that he loved these children. Love doesn't do this. Wickedness, violence, cruelty does this. To have a bullet put in the back of your head by somebody who you love, who's supposed to take care of you, is heinous, atrocious, and cruel. Tamiyah Peters. Remember Dr. Flanagan talked about 10 to 20 seconds after they breathe in the water. So once the water is in the lungs, 10 to 20 seconds. Remember, Mr. Fuchs stopped and waited 20 seconds. That's when you got blood, water in your lungs, and you can no longer breathe. After the lights go out. Well, what did it take before you get the water in the lungs? Your mama has just been beat from one end of the house to another, shot multiple times. Remember the crime scene technique? Children get scared. What do? They run hide. They run hid. Unfortunately, it probably was in the bathroom. So they're hearing this horrendous event occurring outside. Sister has a bullet in the back of the head. Mama has been shot multiple times. Gunshots are ringing throughout the house, and you see it's not the largest house in the world. She's running up and down, trying to get out, trying to fight. Blood is everywhere. Everywhere. She's fighting back. Boom, 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 as she's getting hit in the face. And little ears are hearing this. Then in he walks. After what he did to Brandi Peters, we know he has to be covered in blood. Then he takes one. Maybe it was JaVante. He's at the bottom of the tub. Someone he believes and knows is his daddy. Picked up, placed into the tub, and held down. And what's an actual reaction when you're in the water? Whether if you're 3 years old. You're going to try to get out of that water. You're going to try to stop. You're going to want to breathe. He's held down to the point where all he can do is gasp for air. And when that happens, his lungs fill up with water. And 10 to 20 seconds later, he's dead. Remember, this is after the 10, 20 seconds. The time he had to sit there and listen to his mama being killed, his sister being killed. The time he had to watch in horror as this man walked through the door, covered in his mother's blood. And then him be put in the tub and killed. That, I would submit to you, is heinous, atrocious, and cruel. Then Taniyah. Who is next in line? Now, she heard her twin sister being killed. Boom. And mind you, the defendant's having to reload during all this. His mama shot multiple times, fighting her way from one end of the house to the other, outside the house, back in. More gunshots still ringing out. And then the beating. She's trying to defend herself. Shot to pieces, but still trying to defend herself. All that going on. In walks Henry Segura into the bathroom. Holds JaVante down till he's dead. Then she's next. And this entire time, wondering what's going on, why this is happening, what's about her sister, what about her mama? Oh my God, what he just did to JaVante? And why is he doing this? Why is a man who professed to love me so much doing this? Then she goes into the tub. She's held down, struggling for her life. She gulps, her lungs fill with air, or with water. Not the air she needs. And 10 to 20 seconds later, she's dead. Now, to accomplish this, took some planning, took some forethought. Decisions had to be made. Bridges had to be crossed. Cold, calculated, premeditated. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan, a prearranged design to commit the murder. You know what killing through premeditation means. To this, there has to be a heightened level of premeditation to demonstrate that a substantial period of reflection is required. And this one, a pretense of moral or legal justification. There's no way that Henry Segura can claim that he had any moral or pretense of legal justification for the crimes he committed. We have the dates. We know at some stage, November 3rd, gave him 14 days on the child support. Is this when he started thinking about it and planning it? We don't know. But we know when we look at what he did, how he did it, we know it was, he didn't just walk in and decide to do this all of a sudden on the spur of the moment. We have him outside the house for a very long time on that day, on the 17th. At some point, there was some talking. We know she calls, Brandi calls DOR hotline on Wednesday. We know before the murders occurred, the defendant got up with Tyra Wilcoxon about trying to get the throwdown gun. That didn't work out. He had his own. He had the ammunition. He set up his alibi. He left his phone, his primary phone at home. The other phone he took with him. Some people may ask why. We needed to contact Brandi to make sure Brandi was there and everything else was on his schedule in order for him to get ready to commit this crime. We know he waited in the church parking lot for hours. If you wanted to kill just Brandi Peters, why didn't you kill when it was just her? Why didn't you isolate her? If you wanted just to kill Brandi Peters and JaVante, why not wait till it's just the two of them? He waited 4 hours, and in those 4 hours, he had his protective clothing, because we know there were not a lot of defensive wounds and stuff on him. We know he had enough ammunition with him. He brought enough ammunition to know if the 5 or 6 rounds he had in that revolver didn't work, that he may need more. Why? Because you got 4 people to kill. We have him killing Ms. Peters. We have him killing the 3 kids. Then he disposed of the evidence. And mind you, the cold, calculated, premeditated nature for each of these victims were, he knew Brandi Peters for sure was going to be there. That was somebody we know he fully intended to kill for everything he did. He also made sure the kids were there. He certainly didn't abort the plan because the kids were there. He carried enough ammunition to do the killing of the kids, and he did it. And when he ran out of bullets, he used what he had, which was the tub. The victims, under 12 years of age, 6, 6, and 3. The aggravating factors: previously convicted of a contemporaneous, or previously convicted a contemporaneous conviction of these murders, proven beyond a reasonable doubt. Purpose for avoiding arrest, the witness elimination, proven beyond a reasonable doubt. There was no other reason to kill those kids but to eliminate them, to be able to tell you who killed their mama. Financial gain. He wanted to do away with the Brandi Peters. You know, if you just want to kill Brandi Peters, kill Brandi Peters. If it wasn't for financial gain, then why is he killing JaVante? Heinous, atrocious, and cruel. We covered that. Y'all know that it was. And the evidence shows that it was. And your verdict needs to show that these killings were just that. Cold, calculated, premeditated. That's been proven beyond a reasonable doubt in each of these murders. Been proven that these 3 children were under the age of 12. We ask you, in the case of Brandi Peters' murder, that you find the existence of the aggravating factors presented on the verdict forms, each and every one of them. Find that they warrant the imposition of the death penalty. They are sufficient to impose the death penalty. The mitigating factors, the instructions you heard, anything you want to consider about his background, what he does or what he says, or lack of criminal history. Even if you find those, and I'm not suggesting that you should, but even if you find anything mitigating about Henry Segura, these aggravating factors outweigh any mitigation that you could find or should even consider. And we ask that you return with a recommendation of death being imposed in the murder of Brandi Peters. We ask that you return with a verdict of recommending death in the case of the murder of Tamiyah Peters. We ask that you return with a verdict recommending death in the murder of Tamiyah Peters. And we ask that you return with a verdict recommending death in the murder of JaVante Segura. Thank you, ladies and gentlemen.
Defense will not make an argument, Your Honor.
Right. Let's go back to the jury instructions, page 6. Top of the page. In just a few moments to be taken in the jury room by the bailiff. When you have reached decisions in conformity with these instructions, the appropriate form should be signed and dated by your foreperson. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case, and you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Many of you may have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room during deliberations. Kindly turn those devices over to the bailiff while you deliberate. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. During this trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one decision over another. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. Let's go sidebar, please. Once again, you need to remain with us. We'll let y'all step out, begin your deliberations. We'll be sending the evidence to you. Everybody be seated. All right, well, appreciate you coming back. I know that's tough to not be involved in the other part and then asked to come back. We appreciate your cooperation with that. This will conclude your service with us. We do appreciate the time and attention that you've given. Make you aware of the right, the juror, you have a right to discuss your participation or not. I don't know that whether anyone would inquire of you, but it's possible they would inquire of you. You can talk to people or not as you see fit. You're now excused, so you can govern yourself as you see fit. You can't go back in the jury room. Do you have any personal effects back there? With deputies, we need to make sure Granger's going to get their personal effects. And surprised he's not back by now. If y'all hold there for just a second, he'll be back momentarily. Have we kept the evidence separated so we still have what we went through the other day? We're also sending a copy of the jury instructions with them. I had a copy just printed up, so if they have any questions about the original jury instructions, so evidence can be delivered to the jury. Here he is. Okay. They have some personal effects they need to retrieve for them. We'll let you step out with the deputy. Thank you and have a good day. You can take it with you or not as you see fit. They can't go back in the jury room to get their personal effects. All right? Anything else from either side?
No. We just need to put as a court exhibit the PowerPoint.
All right. Why don't we hold,
Okay.
clerk's got her hands full at the moment. Let's not give her one more thing.
Yes.
But, once she gets back, you can put the PowerPoint as a court exhibit, whatever it would be. Anything else from anyone?
No, sir.
All right, we'll be in recess. We'll hear from the jury.